Hi, I'm Nathan Freeberg of Cave and Freeberg LLP, a court-martial defense firm. Now, we're going to assume for a moment that you've just been handed a charge sheet and been told that you're going to a court-martial. And you probably have some questions about what happens at a court-martial and how is this like a civilian trial and what do you have to look forward to. You've probably seen some movies, you've probably seen some TV shows, you've maybe watched A Few Good Men or a couple other movies that actually show a court-martial, sort of. And you've wondered if that's really accurate and what it's really like. So, some answers. Now, there are a number of steps in the court-martial process, a number of hearings that you have in court before the actual trial. The very first one is something called arraignment. An arraignment is a 10-minute formality, but this is probably the first time you're going to see a military judge. And the first time that the judge is going to ask you a few questions, mainly about your right to counsel, who do you wish to be represented by, your military defense counsel, a civilian defense counsel if you've retained one, like someone like us. And then the judge is going to read you some rights and then tell you the legal effect of arraignment is that if you were to go AWOL, you could still be tried, even though you weren't present. Now, obviously, you're not going to go AWOL, so this isn't really a concern, but that's legally what arraignment is. The next thing that happens after arraignment, or the next time you're in court, is a motions hearing, and you'll probably have one or more than one of those. At a motions hearing, your defense lawyers will make arguments to the judge for relief for various things. And these could be to dismiss certain charges. This could be to force the government to produce witnesses that you've requested, force them to produce experts that they've requested for you, or force them to produce discovery, force them to produce evidence that the government is refusing to turn over or refusing to go get. After the motions hearing, or motions hearings, we finally get to trial. And this is where, for the first time, you're going to see the panel, which is the military term for a jury. Now, the way it's worked is the convening authority, the general or admiral, who's ultimately sort of in charge of your case, at least to some extent, has picked a list of people, or a list of military members. They all have to be senior in rank to you, or have time and grade on you if they're the same rank as you. And there's going to be a pool of them, probably something like 14 to 20 of these members. And they're all going to come in the courtroom, and you're going to stand for them when they come in, and they're going to be in their dress uniforms. And then the judge is going to read them a list of questions. Then the prosecutor is going to read them a list of questions, and then your defense lawyers will read them a list of questions. After that, each member can be questioned individually with further questions that wouldn't be appropriate for the group setting. You have to be present for all of this. And hopefully, your defense counsel, certainly if they operate a trial the way we do, will be asking for your input on each member. And what happens then is the judge will ask the lawyers, do you have any challenges for cause? And this is where a member that has given some sort of answer showing a bias against you in some way, your lawyers will challenge them for cause. And the judge will either grant or deny the challenge for cause. And then we have the remaining list of members. So let's say we had 16 to begin with, 5 were challenged for cause, and the judge granted the challenges. Now we're down to 11 in our hypothetical. Now, depending upon when the alleged offenses occurred, there was a random number generator done on the remaining members, and that could have been done before the trial or it's done at this point. But regardless, the remaining members, again, 11 in our example, are ranked 1 through 11. And this is randomly done. Then the judge will ask each side, do you have a preemptory challenge? And the prosecution gets 1 preemptory challenge, and the defense gets 1 preemptory challenge. And this is separate from the challenges for cause. This is basically, we're just going to challenge that 1 member. And that takes us from 11 to 9. At this point then, 1 through 8 would sit as your jury, as your panel, because a general court-martial has 8 members. And the prosecution has to persuade 6 out of 8 to vote guilty on any charge for you to be found guilty of that charge. So we have our members, we have our jury. Then the prosecutor stands up and gives an opening statement. And this part, frankly, sucks, because you're going to hear a bunch of judgmental things about you and a bunch of things that aren't true. And all you can do is sit there. Then your defense attorney will stand up and give an opening statement. Then it's time for the prosecution to put on their case. The prosecution calls all of their witnesses first, because the burden of proof is on them. And so they will call each of their witnesses in turn, and the prosecution will ask them questions. That's called direct examination. Then your defense attorney can ask questions on cross-examination. Now, cross-examination is the greatest truth-finding instrument known. Nothing is more important to your defense than a strong, accurate cross-examination. It's by far the most important skill a defense attorney can have, is a sound cross-examination. Once all of the prosecution's witnesses have testified, the prosecutor will stand up and say the government rests, or sometimes they'll say the United States rests. After that happens, then it's time for your defense case. Now, sometimes the prosecution case has been so horrible that we're able to say, we're good, Your Honor, the defense rests too, because we don't even need to put on a case. They never got there. But most of the time, we'll call some witnesses in your defense. This is also where you would potentially testify. So the defense witnesses go up, defense counsel does direct examination of the defense witnesses, and the prosecution gets to cross-examine the defense witnesses. At the end of this, defense attorney says, the defense rests. Then the judge will ask the prosecution, do you have a rebuttal case? Sometimes they do, sometimes they don't. But this is where they can call witnesses to rebut in some way something a defense witness said. And then as well, your defense attorneys can actually do a rebuttal to the prosecution's rebuttal. And this could go on for some time. Usually it doesn't, but it could. Once all of the witnesses are done, then it's time for closing arguments. There's some breaks here first to work out some legal issues, but then eventually we get to closing arguments. First, the prosecutor is going to stand up and give a closing argument. Then your defense attorney will stand up and give a closing argument. And this is probably the second most important skill for a defense attorney after cross-examination. Once that is done, then the prosecutor gets to do a rebuttal to the defense case, because the burden of proof always is on the prosecution. After all the arguments are done, then the panel, the jury, goes back to deliberate on your fate. And there's no set time for this. They can be gone for 30 minutes, they can be gone for 2 days, and all you can do is wait. But eventually, they will come out with a verdict. The verdict will be written on a form. It'll be looked up by the military judge just to make sure there aren't any issues with how it's written. And then the panel president, first the judge will say, accused and defense counsel, please rise. And this is where you and your attorneys will stand up. And then the panel president will read the verdict. And if everything has gone right, it will be the two most beautiful words in the English language: not guilty. So that's what a trial looks like. At least that's what a court-martial looks like. I'm sure you have more questions. Please feel free to give us a call. Once again, I'm Nathan Freeberg with Caven Freeberg LLP, a global military defense firm. 202-931-8509. Once again, this is Nathan Freeberg, 202-931-8509.